to 1994. Right? I just explained to you few decisions to make you understand and appreciate how things went. On 25th November 1949, before the Constitution was adopted, a day before that, somebody asked Ambedkar, do we have a federal constitution? Do we have a federation? He said, of course, Indian constitution is purely federal. Whose statement was that? Dr. Ambedkar himself, who was the chairman of the drafting committee. Why did he say that? In its allotted domain, every state is a sovereign entity, independent and sovereign. You got the point? And it possibly was referring to Schedule 7 of the Indian Constitution, which gives 97 entries in favor of the Union government, subject matters on which the Parliament can make the law, 66 subjects or entries in favor of the states, not one or two, right? 66 entries, and 47 entries concurrent, where both the center and the states can also legislate. You got the point? So therefore, when there are 66 subject matters which are exclusive domain of the state governments, how can the Supreme Court say that ours is not federal government? Now when it said, I would like to refer to a few decisions of the court and then let you know the understanding of the court at that particular point of time. And once the Supreme Court says something, the subsequent courts, the judges, they have what you call as precedential value. Previously somebody has said, he has applied his mind, so I will also follow it. Nobody tried to say that it was wrong and therefore it needs to be rewritten. I will just refer to something. Way back in state of West Bengal versus Union of India in 1963, right? The Supreme Court made an observation: Indian Constitution is not truly federal. I can understand somebody committing a mistake. If somebody says Indian Constitution is unitary, they ignore, right? Or somebody says it is federal, we can appreciate. And when somebody says it's not truly federal, either this way or that way, right? Then I don't think you should pardon them. But this is what the court said in 63. Within 2 years, the Supreme Court got the enlightenment, right? And it said in Entry Article 143 in 1965 that Indian Constitution is federal. So from not truly federal to federal. But it is not complete. 1984, in state of Rajasthan versus Union of India, right? The Supreme Court said Indian Constitution is more unitary than federal. I have given you very quickly, right? I'm not getting into the details of these decisions. In the first, they said not truly federal. Second judgment, they said federal. The third judgment, within 20 years, the Supreme Court said it is more unitary than federal. Which, in my opinion, the judges did not understand what is either meant by federalism or unitary constitutions, right? And it took almost 44 years for the Supreme Court to say in S.R. Bommai versus Union of India that Indian Constitution is a federal constitution. Federalism is a basic structure of the constitution. Is a basic structure of the constitution. Now, what do you gain from these 5 judgments that I referred to? Very clearly inhibiting our understanding of what is federal or what is unitary. Now, I read and mentioned that there are more than 24 federations in the world, and you cannot find two constitutions which are identical. You got the point? So it is not unitary or federal constitutions should be alike. Right? They will vary from place to place, from context to context, from one century to another. All these things will change. So you cannot say in a straightjacket formula that if you fulfill these conditions, then you are federal, otherwise you are unitary. There is nothing in between called as truly federal, truly unitary, quasi-federal. These are all norms which I think some people will start writing. And we have got two British writers, which I think I should bring to your knowledge. One was K.C. Weir. I don't know how many of you have referred to K.C. Weir. The book must be available in the library. Indian Constitution is quasi-federal. Now we need a British writer to write about the Indian Constitution because they don't have a constitution of their own. And that fellow writes that Indian Federation is quasi-federal. And all the Indian writers, because the white skin writing something, right, it must be right. So therefore we also started writing quasi-federal, and the judges are no exception to this. But there was also another writer, Granville Austin, right? I am giving you two contradictory statements. Granville Austin, who said Indian Constitution is federal and can be described as an example or illustration for cooperative federalism. So he has not only asserted that it is a federal constitution, but also he was trying to give an illustration that this is the best example for cooperative federalism. Right? And that is what I am going to discuss with you. Right? Granville Austin's small book. I think if you Google search, it is available now. The soft form also is available. I think it is worth reading once. Right? Cornerstone of a nation. Right? So please, when you find time, you just read this. Now, these are all, in one sense, the confusion that we have. And when we have this confused state of mind, not clearly depicting whether the Indian Constitution is truly federal or not, I think the students of law, then the lawyers, the judges, everyone contribute. Right? I would like to bring it to your notice. Can I use this to your notice some prerequisites. Some prerequisites of federalism. I would add one more phrase, essential prerequisites of federalism. When I say essential, there are 5 essential features or elements of a federal constitution. Even if one is missing, you can close your eyes and jump to the conclusion that it is unitary constitution. There is nothing called as quasi-federal, quasi-unitary, nothing. Either it is federal or it is unitary. By and large, our judges looked at Article 352, 356, 360, the emergency provisions, and saying it is because of that it is unitary in nature. Right? Every federal constitution has this overriding power. During the times of war, it has to function as a single unit. Right? West Bengal cannot say we will not give our territory, we cannot move your armies in this way. No, they can't. You have to bulldoze. Right? The existence of the state is primary. Then only you come and think in terms of the state's rights. Right? So therefore, in my opinion, which I think many of the writers have also mentioned, 5 essential prerequisites of a federal government. I'll just give you some illustration as well. It is not that simply I'm going to give you something and then. The first prerequisite is I not like to write written constitution. First prerequisite is a written constitution. I will write to explain very briefly little later. This constitution must also be written. Right? Number 3, supremacy of the constitution. The constitution must be supreme, not the parliament which is supreme. Right? If there was a conflict between the legislature and the constitution, let the constitution prevail. That is what is meant by supremacy of the constitution. The fourth element is very important: distribution of power or division of powers. Distribution of powers or division of powers. And the last one is even more important: independent and impartial judiciary with the power to, with the power of judicial review. If there is a conflict between central states or between two states, there is a final arbiter in the form of the Supreme Court, right, to decide. Article 136 petitions, right, with state versus union, one state versus another state. These are all original jurisdictions of the Supreme Court, and that court has the ultimate authority to decide. Now, when I take distribution of powers, all the 24-25 constitutions, federal constitutions, have different models of distribution. Indian model is unique. Every country has unique models. The American Constitution mentions 18 subject matters in Article 1, Section 8 of the Constitution. 18 different subject matters. Right? The last one is even more interesting. Right? If 17 are very clearly mentioned, and the 18th one is necessary and proper clause. Whatever is necessary and proper to implement above 17 subject matters, the power, what we call it as the residuary powers under the Indian Constitution. And the necessary and proper clause is the residuary clause in the American Constitution. Rest of the subject matters are left to the states. Right? Number 2, in the US, all the 50 states have their own constitutions. So, though I mentioned that the American Constitution is very brief, 7 articles, if you have the constitutions of all the 50 states and place the American Federal Constitution on top, possibly it will stand 3 feet or 4 feet tall. And compared to that, this is nothing. Why? Because our constitution is one single constitution, both for the national government and the state governments. Right? Of course, there is one exception to it, Jammu and Kashmir, and that's in Northeast. Northeast? They don't have their own constitutions. Do they have? They don't have their own constitutions. They are given special status. Right? So you know, these are all instances that took place which are political, and ultimately they take it to constitution and make it. So every distribution is unique. In India, we have the powers of the center. I told you 97 odd entries. Powers of the state, 66 entries. There is also something called as concurrent power, so 47 entries. And as if it is not sufficient, we have got residuary powers, the 4th entry. The residuary power shall be always vested with the union. Whatever is not mentioned in this will be vested with the union. Right? Article 248, read with entry 97 of list 1, gives us this information that the residuary powers will be vested with the union. So this is also another way of looking at and distributing of distribution of power. Professor Burgess, a known political science professor from the Liverpool University, has beautifully narrated this. If the states have one single power, see the beauty of it. If the states have one real power, it is a federal constitution. You got the point? Some real power. Right? I put it as one real power. Some real power, it is a federal constitution. Right? Now in India I told you 66 entries. It is not some, it is many, plenty. As if it is not sufficient, you have 47 concurrent lists on which the states have equal power, like the parliament, to make the laws, and therefore you cannot doubt the sovereign status, independent status of each and every state in the Indian Union. Right? Okay. Now let me test this. I will not explain this in detail. I will just put it like this. Because I have to reflect this so that it is possible for you to keep this in mind. France, UNHCR, right? And India is also keeping in the flagging. Let us also keep, because if I try to explain India these 5 characters, it will take me at least 3 days. 2 hours each. It will take almost 3 days for me to explain these things, because every phrase that we use, right? Every phrase that we use has both legal, political, economic, right, considerations. It is not simple. And therefore, one needs to be very, very clear of what is happening, and when you particularly study these provisions. Right? So let me just ask this question to you. How many articles are there in the British Constitution? Any idea?
So there is no written constitution.
No, there is no written constitution. Very good. So the first attempt itself it fails. There is no point in going through the rest of the conditions. So your conclusion should be, if the constitution is not written, it cannot be a federal model. It cannot be a federal model. Even when you have written down, there are so many complications. When you don't write, you just can't imagine a federal setup at all. Is there any other constitution which is not written? I don't know. We can ask ChatGPT data and find out. We are not able to look at Israel also does not have a constitution. Right? But there may be other constitutions of monarchies, for example, may not have any constitution. And some of the countries in Africa, there is no point in having a constitution also. Right? Because the rebels take over, they start a constitution. After 2-3 years, some of the rebels come and take over. It's a constant change, struggle for existence. So this is one example. First it itself fails. Second one, whether these 5 conditions are satisfied in US, I would say yes. Let me just explain what is meant by rigid constitution. Rigid constitution is one where the process of amending the constitution is prescribed in the constitution itself. Right? And it cannot be done through an ordinary law-making procedure, which means always there are special procedures prescribed in the constitution. The American Constitution has 4 different procedures. I will not go into the details. The Indian Constitution provides 2 different procedures. There is also a third procedure, simple ordinary law-making process. But that is not called as an amendment. If you have the text of the Constitution, will you please read Article 4? If anybody has that. Article 4 of the Indian Constitution. Are you able to follow? Am I going fast? You are comfortable with that? Okay. Article 4 of the Indian Constitution. So if you are not able to get it, I will read. Yeah.
Where is it? So can I?
Laws made under Article 2 and 3 provide for the amendment of the first and the fourth schedules and supplemental, incidental and consequential matters.
So it applies to the amendments made under Article 2 and 3, right? And then please go to clause 2 to Article 4.
No such law as aforesaid shall be deemed to be an amendment of this Constitution for the purposes of Article 368.
So if you refer to Schedule 1 of the Indian Constitution, a plethora of amendments are being made, laws are being made. One example which you should not forget is, earlier we were called the state of Mysore, right? And renaming that as state of Karnataka is also by a statute, right? Reorganization Act of 1956, state changing the name from one to another, reformulating the states. In 2000 you have got number of states, right? UP was divided into more fragments, Uttarakhand, Chhattisgarh and one more state. You might thought of that. So these are all laws passed by the parliament through an ordinary law-making procedure. What is an ordinary law-making procedure? Simple majority. What is simple majority? Simple majority is 50% of the people present, right? Plus 1, not 51%. 50% of the representatives present and voting plus 1 gives us simple majority. So we have around 545 members in the Lok Sabha and 250 in Rajya Sabha. So in the Lok Sabha, if a bill is to be passed, ordinary law is to be passed, how many members are required?
50.
What is 50?
50 members.
Right?
Two-third majority. Simple majority.
No, simple majority is how much? 50% of what? No, that is too high. There is something called as quorum, right? For the parliament to conduct a procedure. I don't know how many of you have visited our Vidhan Sabha, right? When the session is on, if you go to the corridors and stand, you will get a loud bell, ringing bell, electric bell, continuously ringing. Why? The speaker is not able to conduct the proceedings of the House. The Constitution imposes an obligation that at least 1/10 of the total number of members must be present on the floor. So 1/10 of 234, isn't it? Is 24 members must be present. If 24 members are not present on the floor, many of them are in the canteen, many of them are in various ministries, asking for transfers of their own representatives and others. So they are not coming to the floor to do their essential function of participating in the lawmaking process. Now, out of 24 members, are present voting plus 1 is equal to 13 members. 12 plus 1, 13 members. If you take Parliament of India, 545, 279. If 279 members, no, I'm sorry, 54 members, out of which if 28 members pass a bill, it is passed. You got the point? Constitution cannot be amended with a simple law-making process. And that is why a special procedure is given. Where is it given? In the Constitution itself. And therefore, apart from Article 4, the Indian Constitution has two specific procedures in Article 368. I will not get into the details for the time being. That itself is under success, which can go for hours together. Right? So, 2/3 majority of the total number of members present voting is one process. And if the amendment seeks to amend any of the provisions mentioned in the Constitution itself, right? Article 368 clause 2, then apart from this majority, ratification by not less than half of the states is also required. And that speaks of cooperative federalism. Whenever the essential amendments are made to the Constitution, even to redistribute the entries within the Senate schedule, that amendment must be ratified by not less than half of the states. It is not the Parliament can have complete power, right? So, the US also has, France, yes, right? But when it comes to supremacy of the Constitution, all the three conditions are satisfied. Whether they have independent and impartial judiciary in France, the answer is yes. But when it comes to division of power or distribution of power, the fourth element is missing in France. Right? When the fourth element is missing, I told you can close your eyes and jump to the conclusion. The French Republic is a unitary republic. Right? All four are present. Whereas here, only one is absent, which means all others are also absent. Now slowly, independent judiciary is coming into picture. Right after the Supreme Court Act has come into being in the UK, slowly it's coming, but still, that's not the end of everything. So one element, if it is missing, we can jump to the conclusion that the Constitution is unitary in nature. So we are now deciding between federal or unitary. Now comes another important Constitution. I think without telling what it is, I'll add the sixth feature, right? And the sixth feature was present only in the Russian Constitution. Right? Russian Constitution is, if you know the history, 1918 was the first Constitution because the communists came into power, and within 6 years they realized that the Constitution is not working. They destroyed the Constitution and enacted another Constitution. So similarly, France also, when I use this, it is Fifth Republic, which means 5 times they have written the Constitution. What is present today is the Fifth Republic of France, 1949. Similarly, Russia also went through this cycle, not amending one article, removing the earlier Constitution and bringing a new Constitution. 1918 was the first one, 1924 was the second one, 1936 was the third one, 1977 was the fourth one, and what they have is the present one, right? And the term USSR is gone, right? And the new name has been given, right? And in 1977 Constitution, popularly called as Russian Constitution, right? There were 15 states in Russia. There were 15 states in Russia, and the states were called as Union Republics. They are called as Union Republics. Two Union Republics had the power to cede away from the federation and start and becoming an independent nation for themselves. The power was given to two sets, not all the 15, but two of them were given this power to cede away, to go away from the union and become independent nations for themselves. You have any idea as to who the states were?
So maybe one of the Baltic states.
I don't know what is Baltic states. You have to mention. Yeah.
Lithuania.
Huh?
Lithuania.
One is in news in the last 3 years.
Ukraine.
Very good. Ukraine. What is the next one? Bangladesh. So Ukraine and Bangladesh were given the autonomy to go out of the union. If that power is given to Karnataka and Tamil Nadu, right? Possibly things should be different. I hope you understand what I'm trying to say. If that power is given to US, right? US is now aspiring to add Canada as the 51st state. Right? I don't think it will give up any particular state anybody. Right? And it is because of this feature of giving autonomy to the states to move out of the federation, it is called as unique federation. And this unique federation, 1977, it was given only to 2 states. I think subsequently it was given to all the republics, but nobody went out of the union. Why? Because it is a single party democracy. It is a socialist communism, right? The communists rule and continue to rule, and it is the Politburo which takes the decision, right? This independently, no person of taking any decision. So though it was given in 77, for a long period to come, they were not able to exercise that power. But once after the Glasnost and Perestroika, right? Gorbachev, right? They were given and they have become 15 different republics. And Russia also was very happy because they got 15 membership in the UN in one sense or another. So they thought they will have a small clique, right? Ultimately they are fighting with each other, right? And then when you come to Indian Constitution, I can say that all these conditions are present. 6-1 is not necessary. So therefore, there can be no doubt in our minds that the Indian Constitution is purely federal, right? Any excuse that you give, if you take Article 356 emergency power, that the dissolution of the state legislative assemblies, the dissolution is not there in Article 356. But it has become the order of the day, right? If I don't like you, I will dissolve. You go to the court, right? And the court takes more than 5 years, 10 years, right? S.R. Bombay case was in 1986, 87, or 88, right? When Bombay government was dissolved and the house was dissolved. They decided the case in 1994. What did they say? Oh, Indian Constitution is federal. However, we cannot give any relief to the petitioner because subsequent elections have been held and they also completed 5-year term. And what the court was thinking about. Right? You understand all these dynamics. So we have lots of hesitancy in accepting and calling our constitution as federal constitution, or whatever it is. Right? Okay, this is one way of looking at it. What made the Indian, is this clear?
Yes, sir.
So, all the 5 essential prerequisites. Even if one is not there, you have to call it as unitary. There is nothing called as quasi-federal. 4 are present in France. So you call it a 3/4 federation. No, you can't. It is unitary. The second way of assessing, what I call it as a shortcut method. What is the shortcut method? Shortcut method says if you have two different levels of government or 3 different levels of government, right? What are the 3 different levels? One is the central government, right? State governments, local self-government. Local self-government includes municipalities and panchayat raj in India, right? If you have a 3-tier mechanism, forget about the constitution. If there are 3 different levels, you call it as a federal constitution. It's a shortcut. You don't know the constitution, how many articles are there, rigidity is there, supremacy is there. Why unnecessarily break your head? 3 levels of governments, you call it as a federal constitution. If there are only 2 of them, central government followed by local self-governments, right? The counties and boroughs in UK, right? The provinces in France, right? They are all directly under the control of the central government. They don't have independent existence, right? As a structure, yes, it is there, but they are controlled by the central government directly. In all federal governments, the local self-governments are controlled by the state governments, right? If you read if you read entry 5 of list 2, right? And how many LLM students are here? Yeah, the first mistake that you commit, sorry, I'm saying it in the presence of, please don't attend the constitutional law classes without this. At least when you look at the text, you get familiarized with the phrases and where to locate all these things, right? So I call this as Bible, Quran, or Bhagavad Gita, whatever language you want to call, say use that. But without this, don't enter the class. This is mandated in the law school, right? So entry 5, list 2, right from January 26, 1950 was there. What is that? Local self-government, everything present, all the details are given. When you are given, did it function? Right? Whether it functioned at all or not is a question. I'll just give you, written constitution is one, practice is another. India adopted the socialist model of planning, and therefore the central government or the union government, we don't call it as central government, that is for newspapers to write, it's called as union government, had created 2 extra constitutional bodies. I want you to carefully listen to me for next few minutes. The union government created 2 extra constitutional bodies. What is meant by extra constitutional bodies?
So not even in the constitution.
Not mentioned in the constitution, and not even legal bodies, not even under any law. By executive order, these bodies were created. What are they, or what were they?
Planning commission.
Huh?
Planning commission.
Very good. One is planning commission.
Niti Aayog.
The other one?
Niti Aayog. Niti Aayog.
Niti Aayog is now, but before Niti Aayog, there's a planning commission. No, Election Commission is a constitutional body. One more. It is called as National Development Council, NDC. In both these bodies, the Prime Minister was the chairperson, all the Chief Ministers were members, with 2-3 members of the Union Cabinet will also be present. Sometimes the governor, sometimes the Chief Ministers will be the Chief Secretaries. They used to have their own meetings. And at one of the NDC meetings, the Chief Ministers of Tamil Nadu, Kerala, West Bengal, Punjab, and one more state, they all appealed to the then Prime Minister, the leading Machiavellian of the era, that is Indira Gandhi, that we want state autonomy. We want more autonomy to the state. Got the point? We want more autonomy. What is Hindu autonomy? We don't know. But we want more autonomy to the states. The Prime Minister very quickly gave the response. I have absolutely no issue. I will grant you more autonomy, provided you do one thing. What is that? Go back to your states, devolve your powers to the local self-governments, and then come back to me. You got the point? You devolve more powers to the local self-government, come back to me. You don't want to devolve your powers, but you want the Prime Minister to devolve the union powers to the state governments. Right? This answer given by Mrs. Gandhi was the debate, very wonderful debate at that particular point of time. And these chief ministers also said they will devolve, and the fact remains they did not do anything. And luckily, I need to mention to you, after the process of globalization began in 1991, thanks to Nasir, 2 quick amendments were enacted. The Constitution 73rd and 74th Amendment Acts. We have to remember these two because the Constitution 73rd and 74th Amendments. 73rd Amendment speaks about Panchayat Raj institutions, and 74th Amendment speaks about municipalities. What are the functions that are to be devolved have also been mentioned by 2 different schedules, Schedule 11, right, and Schedule 12 of the Constitution. So you can see that the approach itself is now different, right? Somebody asked the question whether parliamentary form of government is good or the presidential form of government is good. And G. U. gave a very beautiful answer. The government which governs the least is the best form of government. Let the fools fight for the form of government. That's what he said. Let the fools fight for the form of government, but the government which governs the least is the best form of government. Which governs? This is the first level of democratic process. You are directly able to access the panchayat leader or municipal leader, who's a model name, each one of them, and therefore the powers given to them in Schedule 11 and 12 are enormous powers, but they are never allowed even today in 2025, to function as units of democracy. Why? They are all controlled by the state government. Must make a law, they make a law, they don't give the funds, right? They don't allow them to do anything they want, right? And when the election takes place, I think Indian politics also a very vague politics. If Congress is in power in Karnataka, if the municipal elections are held, the opposition party will come to power. And the moment opposition party comes to power, the CM will dissolve the local governments. In Punjab, 24 years, not even elections were held. 24 years. The elections were not held for local self-government. Punjab Chief Minister was also one among the 5 Chief Ministers who demanded autonomy for the federal government. Right? So now you have to understand, ultimately, the federal concept rests on the constitutional provisions and also supported by necessary practices. Now, I would like to just move a little, then come to the concept of cooperative federalism. There was one party domination both at the center and the states from 1947, before the independent elections were held by the Election Commission in 1952, 55, right, 57, 62. Congress was the national party at the center, was also the state party in many of the states. But after 62, certain regional political parties started coming into picture. The DMK in Tamil Nadu, the Communist Party in Kerala and West Bengal, right? And when these parties came to power, the Congress Party did not like it. So the first thing they did was use Article 356 to dissolve a constitutionally elected majority government led by the Communist Party in Kerala. It was the first victory. Having tasted that power, that you can dissolve the opponents, you can eliminate the opponent just like that, because Lord Acton, Kumar has mentioned, power corrupts, absolute power corrupts absolutely. So armed with this power 356, and that is why many writers feel Indian constitution is not federal because it gives an edge to the central government over the state governments. It is not. I told you 356 does not speak about dissolution. Right? The center has a duty under Article 355 to take over such governments which cannot run according to the provisions of the constitution and then hand it back to them once the normalcy is restored. Right? That is not happening. Right? So therefore, the local self-governments which came into constitutional status in 1992, another 33 years, you just calculate, I don't think any state government has done anything. There are good examples. Kerala has done a wonderful job, Tamil Nadu has done a wonderful job, Karnataka has done a good job, West Bengal has done a good job, but still there is lots of hesitance on the part of the state governments in allowing them to function within the constitutional framework. Right? Now, in this scenario, something happened in 1977. I hope for the Indo-Pak War in 1971. Right? You know, don't think constitutional law is part of politics. Politics and constitutional law go hand in hand. Right? If you don't understand politics, you will not understand the dynamics. 1971, the war with Pakistan, the war lasted for 14 days, exactly. A new state was liberated called Bangladesh. But the emergency invoked under Article 352 continued till 1970. Right? And in 1975, that emergency was substituted with a new term called as internal disturbances. And the central government arrested lots of political leaders all over the country. And if they are kept in one prison, people may, charge them and release them. So they have been shunted from one place to another. And that lasted for 2 years. And that was the time when the Supreme Court also, please carefully listen to me, Supreme Court also knelt before the central government. How? If you have read the judgment, ADF Jabalpur versus Sultan. Right? 5 judges, only one judge had what you call this, the courage and conviction in favor of the rights of the citizens, and he dissented from that, and that was H.R. Khanna. That was H.R. Khanna, whose cousin is the present Chief Justice of India today. What happened to H.R. Khanna?
He was not the Chief Justice of India.
M.H. Beg was appointed, superseding him. He ultimately had to resign and go. So these are all issues which we need to look at, right? Not simply reading the test, not simply reading the judgment. You should understand the dynamics so that you are able to understand and appreciate what we are reading in the text of the Constitution. In 1977, Congress Party lost miserably, right? What popularly the present Prime Minister calls Today gang. The Janata Party was also Today gang, right? Janata A, Janata B, Janata O, right? All the debates they had. They all came together, they won the election, right? But they were not able to maintain them for more than 2 years. 77, they won the election, and in 77, they did a wonderful job. Such an idiotic job nobody will do. What is that? They identified 9 Congress state governments because at the national election, Congress lost. They identified 9 state legislative assemblies headed by Congress government, dissolved them in one go. And all the when they were thinking about it, the state of Rajasthan has to the Supreme Court. And there is a judgment I refer to, State of Rajasthan versus Union of India. And what did the Supreme Court do? Nothing. 9 state governments were dissolved. Congress was better, it was dissolving individually one after the other. The Janata Party came to power, dissolved 9 of them without giving no rhyme, no reason. Because you are led by Congress Party, that's all. Right? And after 2 years, all of them broke into smaller pieces. It got dissolved. Indira Gandhi came back to power. What did she do? All these 9 state legislative assemblies, where the Janata Party came to power, she dissolved all the state assemblies together. 9 plus 9, 18 state governments were dissolved in 2 years' time. The Constitution does not authorize this. Right? So the tug of war between the center and the states based on party politics is not appropriate, and the Supreme Court did not have the courage to say anything. I hope I want you to keep this in mind. The Supreme Court did not have the courage to say anything. Right? Now that led to ultimately in 1986 the Government of India to constitute the first committee on center-state relations, popularly called as Sarkaria Committee, Sarkaria Commission, right, on center-state relations. And I don't know what they have written, very lengthy recommendations, right? And in the lengthy recommendation, the one such recommendation was, which I think leads to Cooperative Federalism, is that the Interstate Council, which was supposed to be created under Article 263 on 26th January 1950, has not been created, and therefore they insisted that they recommended what was already there to please establish the Interstate Council under Article 263. The Government of India took 2 years time. In 1990, they implemented it. In 1991, the Secretariat was established and the Interstate Council came into existence. From 1991, we have to now be critical of its functioning as well. From 1991 to 2025, only 11 meetings are taken place. Only 11 meetings are taken place. Of course, NDC does not meet and decide the way it wants. The planning commission has been given a go right, and in its place you have Niti Ayog. Right? The second commission which you should remember is the National Commission for the Review of the Working of the Constitution 2000. 1988 was Sakara Commission, and before that in 1970s there was one more commission constituted by the state government of Tamil Nadu. Right? And that was constituted by the state, that's why it was preferred. So National Commission also made lots of recommendations, but nothing came out of that. You know who headed this commission? National Commission for the Working of the Constitution. The person from Karnataka. Huh? Justice Ambedkar was the chairperson. It also gave lots of recommendations. Nothing worked. In 2005, the government of India constituted one more committee. Right? It's called as Poonchi Commission, and Poonchi Commission is before. Remember Poonchi? So remember that spelling is always misleading. Poonchi Commission. If we carefully look at the contents of Sakare Commission recommendation on one side, Poonchi Commission on the other, Poonchi Commission recommendation revolves around development, not on politics. Revolves around development. You got the point? And then, now combining that with the second Administrative Reforms Commission. Who headed this commission? Again, a person from Karnataka. Who's that? Vijayakumar. Right? I think one day I can bring him. Such a wonderful speed and release. Right? If the director tells me, I can bring him. He was a former chief minister, former education minister of Karnataka, former law minister of Government of India, former minister for corporate affairs, Government of India, right? And a wonderful speaker, right? And he has spent series of reports under the second Administrative Reforms Commission. This is center state issues, the state issues, right? Governance, right? All of them will be on the list. So the focus slightly shifts from politics to economics. You have to point it from politics to economics. So when it shifts from politics to economics, we need to understand that there must be some cooperation. Right? We cannot constantly keep on making. So that cooperation, if is, as I mentioned to you earlier, right, that Granville also mentioned that it is an example for cooperative federalism long ago, right? And I think the Supreme Court used the term cooperative federalism in one of the judgments. The elements of cooperative federalism is writ large in the Constitution. Look at Finance Commission, right? How the money is to be distributed between the center and the states on the recommendation of the Constitutional Authority called as the Finance Commission. The exemption of property from each other's taxation, right? All these things are beautifully mentioned in the Constitution itself, right? We picked up only the political part of it, but we forgot all the rest. And therefore, when all these things took place, with the process of globalization coming into picture, I want you to keep one thing in mind. My job would be well done if you remember this one slowly. Now, when you have this strict federal model, who made the policy? Central government made the policy. State government made the policy. Imposed on each other. Right? Now, many of the policies are outside the realm of the Constitution of India. When you adopt this process of globalization, I would like you to keep this slogan in mind. Globalized policy making and local implementation. Very simple formula. Globalized policy making. I think in LLM we have a paper, isn't it? Global justice. Globalized policy making and local implementation. What is meant by local implementation? Wherever it is necessary, it must be implemented by central government. Wherever it is necessary, state government must implement it. Wherever the local government is there, it is called as local implementation. At all three levels, whether they envision anything called as local self-government, the answer is yes. The Rio Convention, Agenda 21 on local self-government is a marvelous document which speaks about the migration of people from rural areas to urban areas and the complications and the problems that they are going to face, and therefore they must address that at the local level. The state government should fund them, right? And then, who makes the policy? What are the policies that we are talking about? Let me just give you 2 or 3 or maybe 4. The first and the foremost is the local Agenda 21, 72nd and 73rd and 74th amendments that I already mentioned. Second one is immediately thereafter, 1993, the Protection of Human Rights Act, right? Where the overseas governments were contesting the Indian government. If you want additional funding from our side, it is better you establish Human Rights Commission. Now, human rights reports are being submitted to the UN periodically. Now, you have specific reports on women, children, what not. Right? I think the right person is Prof. Subramanian to speak about these situations. Right? Who makes the policy on human rights? The right from UNHCR. Right? The conventions to which India is a party. Right? So today, therefore, you see the drastic violations that were taking place in the country till 1993 do not take place today. I'll give you one illustration for this. Ever since NHRC came into the picture, it delivered the annual reports in which it said the state of affairs about the custodial deaths. So it said UP has more than 110 deaths. Custodial deaths, whatever is the reason. Bihar 125. So now the state started fighting. You are the worst state. You have more custodial deaths. So you have to defend yourselves. And thanks to these reports, over a period of time, today the custodial deaths have come to, it is not completely eradicated, it has come to ban. Right? The moment there is, it is not only states concerned now. If there is a custodial death in Karnataka, it becomes an issue at the center, it becomes a center at the global level. Right? Somebody from there will call the government of India, why there is a death, please look into. Who makes this policy? Global policy making and local implementation. Second one is environmental protection. Right? whether it is climate change, whether it is whatever thing that you are talking about, whether it is related to water, right? Everything is decided at the global level, and we try to implement it. So we become only partners in implementation, and we make only secondary level policy choice. My apologies. Do you have time? Okay. So therefore, friends, I would like to mention to you please read two articles. Article 243 ZB, ZB. Is one of the best illustrations for cooperative federalism. Second, opposite article 279A. Article 279A. This is also process of development, right? GST. The GST Council and the distribution of revenue between the center and the states. Lots of funds. Article 292, 293, borrowing powers. These are all illustrations of cooperative federalism. It is because of this, not many changes have taken place. What are they? I'll just give you a couple of things. There are two phases that are going on. Along with cooperative federalism, there is also something called as competitive federalism. Competitive. Cooperative federalism and competitive federalism. And if you visit the Niti Aayog website, they have even proposed something called as competitive cooperative federalism. Competitive cooperative federalism. Now, what is this competitive federalism? That's why I refer to Article 279A. The GST, where the producing states have lots of contribution to make, because everything that you produce you have to pay tax. But there are 11 states, 7 of them are north-based, they don't have industries, right? And they cannot contribute to the pool, the GST pool in any meaningful manner. And therefore today, you must have seen the political interest. The Chief Minister of Tamil Nadu, Chief Minister of Maharashtra, Chief Minister of Karnataka, they are saying we are contributing the maximum to the pool of direct taxes and indirect taxes. You got the point? And therefore we should get the maximum. And that is not the logic. The logic is, if you take your body, if you say that only your head has to develop, only your right hand has to develop, right? Indian Union has to develop, all of them must develop simultaneously. And therefore, the logic that I contribute so I should get more does not hold water. And that is a case where the states contribute for the development of 11 states. I don't want to mention the names of 11 states. It is there in Article 279, special status to 11 states. Though they don't contribute, they also get the fund from the central government for their own development. Right? And in the same article, how beautifully cooperative federalism is mentioned. Please read it to certain once in your lifetime at least. And particularly the LLM students should read how the National Council, the GST Council makes decisions. Right? And I think that will give you the details of cooperative federalism. What is competitive federalism? Right? I have few illustrations. Today, I think sometime in November 2024, if you visit Niti Ayog's website, you will find it is a report released by the Niti Ayog, ranking of states in sustainable development goals. Ranking of states in sustainable development goals. So now they have created a sort of ranking, which state is better. And if people present in the other states will question why can't we do it? So today, in this process, I just end with this statement. Many of the states are inviting foreign direct investment. Right? Foreign direct investment meetings are taking place in most of the states. Right? The center is allowing them for the direct flow of funds from outside to the respective states for the development of the state. Right? I hope there are many illustrations and details of that. Therefore, ladies and gentlemen, if somebody says Indian government, Indian constitution is not federal, right? Please ask them to make me. Right? Otherwise, you should be in a position to different lessons. Right? And stop here. I'm sorry, I'm not giving one, but still, that's all I'm saying. If you have any questions, yeah, water disputes, I don't think so. That is why the power is taken away from the Supreme Court. Right? And water is going to be a major issue in the years. So you have to use the cooperative method rather than the conflict.